Good morning.
Very good. All right, we are ready to proceed with the case of Stevenson versus Stevenson. Mr. Frazier, you may proceed.
Yes, Your Honor. And at the outset, I would like to retain 5 minutes for rebuttal argument.
Very good. I'll let you know when you get there.
Thank you, Your Honor. Excuse me, and I apologize for my voice. I'm recovering from a cold.
No problem.
Your Honor, this is a case where the wife and appellant, Ms. Fatten Stevenson, is appealing from the trial court's denial of her motion to dismiss for lack of subject matter jurisdiction based on the children's home state being Michigan, not Florida, under 61.514, the UCCJEA, and the denial of her motion to transfer venue under 61.520. At the outset, I would like to acknowledge that the proper standard of review for both issues is abuse of discretion rather than de novo, as I had previously contended. Therefore, the issue is going to be whether or not any person could have taken the trial judge's position, which I do not think that they could. The trial judge made its decision that Ms. Stevenson has been a resident of Florida since November 14th, 2020, where the cutoff date for the 6 months under the UCCJEA would have been on September 12th, 2020. However, in doing so, the trial court ignored its own findings. The trial court, in the oral transcript of its ruling from November 4th, stated that it understands that Ms. Stevenson testified that she had resided in Michigan since at least 2019. The trial court acknowledged that she had produced purchase agreements from trailer homes from 2019 and 2020. The trial court acknowledged that Ms. Stevenson's sister, Fariziah, had acknowledged that she had been residing with the family in Michigan in 2019 and had frequently been tending to the children in Ms. Stevenson's absence whenever she was unable to watch the children. The trial court noted that none of this testimony was unrefuted, and the only testimony that, to the contrary, really came from the husband, Mr. Andrew Devin Stevenson. However, even though the trial judge claimed that he's taking the husband's testimony as gospel, that Ms. Stevenson was temporarily absent from Florida and her actual residence was in Florida, the trial judge also noted in that same order that the husband had no personal knowledge as to the children and family's whereabouts in 2020. That's something that all witnesses corroborated. There's really no evidence showing that the family has been living here since 2020, as I believe the trial judge had stated.
So, Mr. Frazier, let me ask a question relating to the legal aspect of this. Isn't it a question of the intent of the parties as to where their residence will be, or will it change? Isn't that one of the aspects of it? What's the intent? For example, is she in another state temporarily or permanently? Has she chosen to make that her home? Is that one of the elements that goes into this?
Your Honor, I believe that's one of the elements as it goes to residence for the purpose of whether or not the court has jurisdiction to dissolve the marriage just dissolve the marriage. It has nothing to do with jurisdiction over the custody issues, which is what this appeal focuses on.
But the question of venue, which goes to where were the parties residing? Where was the marital residence for the prior 6 months? And so it seems like your client's position has been, we moved and our intent was not to come back to Florida. Our intent was, in fact, to move permanently to Michigan, right?
Somewhat, Your Honor, and this is a bit of an unusual case in that the husband...
Well, let me interrupt for a moment, because one of the other unusual aspects of this is your client in her answer admitted that the domicile was in Florida, and then she filed a counter petition which she signed. So it wasn't simply counsel making an allegation. It was something she signed that also alleged that venue was proper in Florida, that was where the marital domicile had been for the prior 6 months, correct?
Yes, that is correct, Your Honor. And
she maintained a driver's license in Florida. She maintained voter registration in Florida. and the homeschooling, and I understand what homeschooling is. It can happen anywhere, but it was being conducted through a Florida homeschool organization, correct?
Not correct, Your Honor.
Okay.
The organization, Abeka Homeschooling, is a nationwide program. And in fact, in Michigan, one of the party's minor children continued to use that program despite not residing in Florida. That's not something that would be possible if this was.
Well, wasn't the contact person a Florida person? I thought there was something indicating that their dealings with the homeschooling organization were all in Florida.
Your Honor, I believe that's referring to Miss Jeanette Arcia. She was somewhat of a point of contact for the parties, but she never actually taught the children, communicated with the parents, never met the children or the parents. She was merely the administrative official whom the parties would submit the children's grades to.
Okay. You can proceed.
Thank you, Your Honor. And Your Honor, the fact that she had signed a counter petition alleging that the marital home resided in Florida, the marital home did reside in Florida. However, she did not reside there. And if anything, I think that would be an error of, unfortunately, not understanding or having the legal savvy to really understand what she had been signing. All of her testimony.
But she was represented by counsel, wasn't she?
She was represented by counsel.
So was it her not understanding, or did counsel fail to adequately advise her? I mean, she signed, presumably having read the document that she signed and having gone over it with counsel. I don't want to dig into attorney-client privilege, but you know, that's what the record reflects, and presumably it's a fact that the court could take into account, and did.
Thankfully, Your Honor, we do not have to dig into attorney-client privilege because a different attorney had handled the case at that point. I had come on board with a notice of substitution of counsel in September of 2021. And Your Honor, the trial court in its ruling specifically relied on the husband's allegations that the parties had been residing in Florida and that their absence in Michigan was only a temporary leave of absence because this was a, quote, vacation home. However, the trial judge also acknowledged that the husband had no personal knowledge and had no idea where the children were during 2020. In fact, if what the trial judge says is correct, that the parties, that the wife had listed the marital home for sale in 2020, June of 2020, and had since then been coming back down to Florida simply to perform routine maintenance and to check on the property, June would put us well outside of the September 12th cutoff for the purposes of having UCCJEA home state jurisdiction under 61-514. And Your Honor, as it refers to venue, I believe that some of the factors were incorrectly considered by the trial court. The length of time that the child has resided outside of the state. The trial court simply relied on the fact that it believed that the children's home state was in Florida. It did not perform any deeper analysis than that. But even assuming that the trial judge's allegations are correct, that the children had not resided in Florida since September 14th, 2020, at the time that the order was issued in January, the children would have been residing outside of Florida for 16 months at that point. The fact that the evidence, the nature and location of evidence required to resolve the pleadings, the trial court made a statement that Zoom obviates that issue. Respectfully, Zoom does not obviate that issue. Certainly, it might be easier to present evidence via Zoom, but if we're talking about maintaining a case in Florida and subpoenaing evidence in Michigan, now we have to get into the issue of getting the Michigan courts to recognize Florida subpoenas, substantially slowing things down and increasing costs to both parties. And the familiarity of courts with I'm trying to keep my throat clear. The familiarity of the courts of each state with the issue. The trial court mentioned that there have been 2 hearings on this matter. Respectfully, the 2 hearings that the trial court is referencing are only on this motion to dismiss and have nothing to do with the 6113 factors that would deal with childcare, Your Honor. Basically, the trial judge said—
The dissolution proceeding is occurring in Florida. Everyone agrees that the dissolution part of this is proper in Florida, correct?
Yes, Your Honor. As to whether the parties can have the marriage dissolved, setting aside any issues of child custody, Florida would be the proper venue for that issue. And one thing to point out, Your Honor, I noticed in opposing counsel's answer brief, they had stated that all inferences and all conflicts of evidence must be decided in favor of the non-moving party, the husband. That would give the husband an extreme advantage, especially when dealing with an abuse of discretion standard. However, after reviewing the case law cited by opposing counsel, I think it's been misinterpreted. The cases that opposing counsel has cited referring to interpreting evidence in the light most favorable to the non-moving party all have to do with cases involving the appeal of a motion for directed verdict, which would involve giving the non-moving party the benefit of the doubt in terms of resolving conflicts. That's not the case here. We simply have to decide whether or not there is competent substantial evidence supporting the trial judge's decision, or said differently, whether or not any reasonable person could have taken the trial judge's position. And quite frankly, I don't see where they have. The children have been attending extracurricular activities in Michigan, which the trial judge knew about. The wife has been up in Michigan making substantial purchases from as far back as February 2020. Those records were submitted into evidence. The flight record showing her frequent flights back to Florida to check on the residents and then promptly flying back to Michigan were promptly submitted into evidence. The purchase agreement for the 2019 single wide trailer properly submitted into evidence and acknowledged by the trial court as unrefuted, while corroborating the sister Fariziah's testimony that the parties had been residing in Michigan since 2019, and she had in fact been helping out with raising the children since that time. There's simply no connection to Florida or no evidence supporting the idea that Florida is these children's home state, except for the husband's testimony that that's where the children have been living, which quite frankly, I can't see carrying any amount of weight or being any kind of credible, considering the trial judge explicitly stated that the husband had no knowledge of the matters to which he's testifying. The only thing really supporting keeping the case in Florida would be the erroneous filings, none of which were verified and all of which were contradicted by testimony from Ms. Fariziah and from the wife herself, in addition to all exhibits admitted for the trial court on August 13th and November 3rd, if I'm remembering correctly. And Your Honor, if the panel has no further questions, I will reserve the remainder of my time.
Very good. Thank you very much, Mr. Neumeyer.
Yes, good morning. May it please the court. This case involves a lot of conflicting evidence. There was evidence by each party. There were also conflicts in the evidence within the scope of what the wife had provided. As Your Honor pointed out in her answer and counterpetition, the wife made written representations that Florida was the primary residential home of the parties for purposes of a divorce, as well as admitting the allegations contained in his UCCJEA declaration by reference. But she did not merely write an agreement with those. During the hearing on August 13th, she, under oath, again confirmed that everything in her answer and counterpetition was true and accurate. That was at page 160 of the appendix. So in this case, it's being presented that while the mother's evidence was all one way and the father's evidence was weak the other way, number one, it's not a question of weak or strong evidence. It's competent substantial evidence. Any competent substantial evidence to uphold the court's decision renders the case not an abuse of discretion. But within our case, the court was specifically tasked with determining the credibility of the wife. She took three different positions. In her answer and counterpetition, she said, yes, Florida is where the kids have been. Then in her motion to dismiss, she said, no, it isn't. Then at the hearing, she took both, yes, everything in the answer and counter petition were correct, but I also instead lived in Michigan. This is exactly the kind of factual determination that trial courts are directed and required to make. And in this case, the court did make a credibility determination, obviously. This is not just a case where, well, did the husband know or not? We have sworn testimony from the wife. We had the fact that her driver's license was still in Florida in 2021, which under Florida statutes, I believe she's required to update that after making a permanent move. In 2021, her voter ID was still in Florida. We didn't have any testimony as to whether she voted in the 2020 election, but clearly that could have been problematic for her. That's another indication that yes, she was in fact a resident and intending her permanent residence to continue to be in Florida. While the husband testified that the Michigan trailer was only intended to be a vacation home, the foundation of his knowledge was not challenged at the hearing. There was no objection. There was no move to strike that testimony on the basis of a lack of foundation. That testimony came in, and the court was entitled to give it whatever weight it felt was appropriate.
Mr. Neumeier?
Yes.
Does home state contemplate something more than mere presence in the state?
I think it does, because it specifically includes an exception for temporary visits outside of the state. So if it was a black line rule that we only look at the number of days the children are physically present in a statute, in a state, then that language in the statute would be unnecessary and confusing, but it's not.
So the fact that the husband may have testified that he didn't know where the kids may have been on a particular date is not inconsistent with his testimony that the home state is Florida.
It isn't. I believe if you look, and I am talking from recollection here, I think he was cross-examined. Do you have personal knowledge where the children were? And that may be subject to, you call somebody up at the Florida number, kids are laughing and screaming. Wife says, yeah, they're out in our pool swimming. That is not personal knowledge. That's hearsay as to what state that phone call is being received in. So I think he could say, yeah, I don't have personal knowledge, and yet his testimony could have substantial evidentiary weight for situations like that. There was no follow-up cross-examination to get deeper into that foundation. The mother excused herself from the idea that although she had received the tax benefits and lower tax expenses from the family budget for having the home homesteaded, her position was, well, I had nothing to do with that. That was the husband. But there was no evidence that she ever objected to it being homesteaded. She says, well, the evidence shows that I lived in Michigan because most of my expenses were paid there, and I owned a double wide. But the evidence was clear that they had owned property in Michigan going all the way back to 2016. There was no position asserted that the parties had their permanent residence in Michigan throughout that time period while still having not one but two homesteaded properties in the state of Florida during the same period of time. So I think there was plenty of evidence from which the court could have determined, yeah, the massive separate home that's homesteaded in Florida that the wife did come to maintain while it was up for sale, presumably while it was empty for showing conditions, was still their primary residential place of residence, and that the trailer that was bought on a property in Michigan, as their history had been for years before that, was just solely a vacation property. The husband also testified that the parties had discussed and agreed that when he returned to Florida, he would be a student at a college in Florida. That testimony was unrebutted. I think that there's some inference there that they would all be living together, not, I'll be going to school in Florida while she resides in Michigan. In this case, as I outlined in our brief, there was a lot of evidence in the wife's favor, but there was also a lot of solid, competent, substantial evidence in the husband's position. The court was entitled to feel like the mother is trying to second guess her initial pleadings and take a legal position she believes is better for her. And the court was entitled to disregard her attempts to explain away her reasons for changing her story 180 degrees. Briefly on the venue issue, the difficulty in pursuing subpoenas across state lines, that would be true whether it's a Michigan court trying to get Florida witnesses or vice versa. And there is a Uniform Foreign Subpoenas Act, which I believe, and that would be, well, I won't even make that argument, but it is a uniform and Florida has it. I think there might be some indication that Michigan does as well. In terms of all inferences being in favor of the husband, we don't even really need to get there. My argument was the wife is arguing all of the inferences in her favor. If the inferences are neutral, we still should win on this particular issue. That's pretty much all I have to say, unless the panel has any other questions for me, Your Honor. This order should be affirmed, and the proceeding should continue. One last point was, as the court noted, the wife never filed anything in Michigan for there to be a court for the case to be transferred to. There is only one court currently considering this, which is Florida. As the transcripts reveal throughout the preliminary battles in this case, the husband was still not getting any visitation with the kids. So that is another reason for the court to determine whether the wife's change of position was really an honest mistake, or whether it was a deliberate attempt to manipulate the system. Thank you.
Very good. Thank you, Mr. Neumeier. Let's go back to opposing counsel, Mr. Frazier.
Yes, sir.
For rebuttal.
Thank you, Honor. And there's quite a bit that I'd like to go through. Your Honors, the opposing counsel had stated that there were no statements by the trial court as to the credibility of either witness, and that's simply not true. I understand opposing counsel's position that the husband could have known these things. Maybe he had or had not personal knowledge. But on 394 of the record, lines 16 through 19, the trial court explicitly stated, your client, referring to the husband, has been absent overseas for the majority of the time. He doesn't really have any personal knowledge where exactly the children were located. Excuse me. The UCCJEA affidavit that the husband filed falls to the same fallacy. Anybody can write that that's where he believes the children are residing, but he admitted during the hearing on November 3rd, that he did not have any personal knowledge of where the children were residing. And that is a fact that the court specifically found in its ruling.
Your client did not file a response to that, did she, saying that the children, in fact, were in Michigan?
She did, Your Honor. She did file a UCCJEA affidavit mid-July of 2021 stating that the children had been living in Michigan.
But not in response to his filing at the time she filed her counter petition?
No, Your Honor. And not having been counsel at that time or having known Ms. Stevenson, I would be guessing as to why.
But she was counseled, just not by you.
Correct, Your Honor.
Okay.
Your Honor, the other issue that I seriously take issue with is the opposing counsel's allegations or implications that the trial court has stated, or at least held, that Ms. Stevenson is trying to change her testimony mid-case, potentially trying to switch horses mid-race. But reading the oral ruling from pages 394 till I believe 402 of the provided record on appeal show that that's not the case. In looking at the purchase agreements for the mobile homes in 2019 and 2020, the court found that that was unrefuted. In looking at the sister, Farah Zaya's testimony, saying that they had been living in Michigan since 2019 and that she had been regularly helping care for the children in 2019, was unrefuted. Your Honor, this isn't a matter of weight and whether or not the trial judge could have had believed one witness over another. The trial court explicitly.
And is the same, is saying that something is unrefuted the same as saying it's credible? And was the court obligated to accept it as true if it was unrefuted?
That's an interesting question, Your Honor. I don't have an answer off of the top of my head. I don't think grammatically that unrefuted would be the same as credible. However, the husband's testimony was not specifically stated to be credible, and it was refuted in comparison to the wife's testimony and her sister's testimony, which were unrefuted. Your Honor, we mentioned that there is no case in Michigan. Correct. There is no case in Michigan because Ms. Stevenson is of limited financial means and has not received any financial assistance during these proceedings. But that fact is neither here nor there. When referring to the evidence when it turns to venue, yes, opposing counsel is correct in that the issue of getting interstate subpoenas applies regardless of whether the case is in Florida or Michigan, but that rests on the assumption that there is equal evidence in Michigan and Florida, and that's not the case. The only evidence in Florida is the husband himself. He is the only person living in Florida. The wife's family, including numerous siblings, both of her parents, and the husband's family are all living in Michigan within about an hour of the double wide trailer that the children and wife have been living in since 2020, and about similar distance from the trailer that they've been living in since 2019. And as to opposing counsel's allegations or our argument that they've had property in Michigan since 2016, it was a vacation home at that point. That's fine if the 2016 home was a vacation home. That's not the issue. The issue was the nature of the 2019 and 2020 homes, which all evidence stated were to be permanent residences. The only testimony to the contrary came from the husband, who acknowledged no personal knowledge and who the court explicitly stated in its order that there is no personal knowledge. While the court did not specifically use the phrase credible or uncredible, the fact that the court is directly stating that the husband has no personal knowledge must call the husband's credibility into testimony. And if all evidence stating the children's location in Florida comes from the husband's testimony, then I would submit that there is no competent substantial evidence, that no reasonable person sitting in the trial judge's position could have made that decision with the overwhelming amount of evidence showing that the children and wife have been living in Michigan since at least 2019. And as to the agreement supposedly between the parties that the husband was going to be living in Florida for education, that was never discussed between the parties nor agreed upon by the wife, and nothing in the record reflects that.
Mr. Frazier, you're about the end of your time. Take a couple seconds to wrap up.
Thank you, Your Honor. Your Honor, that pretty much concludes my argument unless the panel has any other questions. Beyond that, I would submit that the trial judge's position should be reversed and that this case should properly be heard in Michigan, either through lack of Florida subject matter jurisdiction or through transfer of venue to Michigan under 61-520.
Very good. Thank you very much, Mr. Frazier, Mr. Neumeier. Appreciate the arguments. You may leave the courtroom. The next case
Thank you, Your Honors.
You're welcome. We will have